Hi, I'm Shan Wu with an undercolor of law analysis of Volume 1 of Special Counsel Jack Smith's special report. It's finally out. This is the one about the election interference case, as distinguished from Volume 2, which will be about the Mar-a-Lago case involving Trump hoarding classified national security information. Volume 1 we often refer to as the January 6th case. Volume 2, sometimes they call it the classified documents case, but it's really much more broad than that. It's really holding on to documents he shouldn't have that involved in national security. Volume 2 is still bollocksed up by Judge Eileen Cannon's efforts to stop release of any special counsel reports, as well as Merrick Garland's kind of struggle over whether the release of the Mar-a-Lago report might hurt the rights of Trump's co-defendants, among them his faithful body man, Walt Nauta, another co-defendant who was a handyman at Mar-a-Lago. One does question why they don't just dismiss those cases too. It would have been one thing to refuse to dismiss Trump and their cases until the Trump DOJ came in and dismissed it. I mean, that was my view, make Trump's people kill it in sunlight. But DOJ and Smith felt they had to dismiss Trump in light of the Supreme Court decision about immunity. But if that's the case, why bother keeping in literally the body man and the handyman? At least that way there wouldn't be an issue for Garland to have to work his way through about whether it might prejudice those defendants to release the report. Anyway, it's arguably one which may contain less information that's already known, because that one has been much more secretive. So that would be important to learn about, because we'd like to know how Trump will take care of our national security. But those are mysteries for Attorney General Garland's mind and how he thinks he's defending us and defending the reputation of the Justice Department. So let's get to Volume 1, the January 6th case. This is the one Eileen Cannon did allow to slip out. As expected, and in some ways criticized and disparaged, the report is not revealing a whole lot of brand new unknown information. But that way of characterizing it, I want to put forth for your consideration, I think is wrong. It's a function of us having a numbed down kind of reaction to news, and in part thanks to the overused breaking news, mainstream media's 24-hour search for dopamine hits. Give you one microcosm, an experience of mine. The mass media platforms I was scheduled to appear on about the release of the Jack Smith report all ended up not doing significant segments on the report at all. I mean, going from a time when it was 24/7 Jack Smith to now it's like, okay, it's over, it's just like a footnote, not even covering it anymore, because it's considered just a piece of history now. Too often we disparage events as, oh, this is just for historical reason, meaning it has no importance now, or maybe politically it's not sexy. History is, of course, important, but even more important is how the history is being made. This report is the official document, the historical record that sets forth forever in the National Archives of how the incoming President of the United States tried to overturn an election that he lost and all those who helped him do it. Put up the opening to the report, and I think there are three takeaways I want to talk about. There's a lot in there, and you should certainly feel free to read it. It's pretty easy to digest, but here's the first takeaway. Trump's state of mind is addressed. Over the years, I've been on countless panels talking about his state of mind. Could we prove it? How do you prove it? It's circumstantial. How do you ever know? Trump insisted on challenging the election, and Jack Smith sets forth how they would have proven the state of mind and really what the proof is. He wanted to use illegal means to stop him from losing that election, even when he was being told he'd lost. That's set forth. That's how you overcome the state of mind question, is everyone's telling him this is not true, this is illegal, and he still wants to do it. Along those lines, the report also shows why the so-called advice of counsel defense wouldn't have worked. This is stuff we already know, but it's put together in a neat way to see it, which is, in the report, it talks about how VP Pence pointed out to Trump that Trump's own lawyer, John Eastman, was telling Trump that Trump wanting Pence to reject the Electoral College, send the votes back to the states, was illegal. To which Trump responded that he, quote, liked the other thing better. Note the kind of mob boss ambiguity of the other thing. That other thing was having Pence just reject electoral votes from the 7 states where Trump lost, which Eastman also submitted was illegal. As brilliantly pointed out in the publication Just Security by Tom Jocelyn and Ryan Goodman, this would have undercut, if it came out in testimony, Trump's advice of counsel defense, because it's his own lawyer admitting that he would be violating the law with both proposals, that both ideas could not be justified under the law. The second thing, there's been a lot of talk about why didn't Smith just charge Trump with inciting insurrection, because that kind of dovetails into the question of if there'd been a conviction or finding that he incited the insurrection, would have made it easier to bar him from office under the 14th Amendment. Here, Smith gives a very fulsome explanation of why he didn't do that. He gave careful consideration to it, but in the end, he decided there wasn't enough evidence to show Trump had the intent to cause, in their words, the full scope of the violence that occurred on January 6th. And also the fact, I'm quoting here, there does not appear to have ever been a prosecution under the statute for inciting, assisting, or giving aid or comfort to rebellion or insurrection. Translation, either he was afraid he might lose that count, or he might lose it before the jury. So let me explain. He might lose the count first, maybe on a legal motion to dismiss. Second, he was worried that maybe the lack of that concrete evidence of Trump literally telling people to go do the violence until they overturned the government would have been a loser before the jury. Now, the first point, that he was worried about losing it on a legal motion, I think would be more alarming to Smith than the second one. Why? Because it takes time for that dismissal to happen. It's got to be litigated, work its way through the courts. We've seen the endless appeals. It would have gone to the Supreme Court. And time was the one thing Jack Smith did not have. As to the jury, yeah, that's a consideration. You have to think about whether you're going to win, but that only would have been one count. And frankly, an aggressive prosecutor charges anyway. If they throw out that count but convict him on something else, that's fine. It doesn't strike me as Smith was the kind of prosecutor who's very afraid of tough cases. This is a man who tried and lost a high-profile case against former presidential candidate John Edwards. Remember that? Now, before I get to the third takeaway point, I have to note the reaction of CNN's Elie Honig to the report, in which he describes it as being defensive, overly dramatic. So take a listen here.
This is far more dramatic, far more, frankly, defensive by Jack Smith. He quotes John Adams. He quotes, highfalutin language from prior attorneys general. He really wraps himself in the righteousness that he sees around this investigation. So that is something unlike what we've seen before. Although I will say, we got another special counsel report earlier today from the David Weiss, who prosecuted Hunter Biden, which actually has a similar introduction. So usually special counsel reports are quite dry. They're just facts and law. But the two that we got today are unique in that both of them are very defensive and really strike back at the people who've been criticizing them. Jack Smith strikes back aggressively at comments that Donald Trump has made, and to a lesser extent, but still palpable, the Hunter Biden prosecutors strike out at Joe Biden for his criticisms.
I have to disagree with Elie on this. Contrary to what he says, Smith's report does do what it's supposed to do. It sets forth the facts, it sets forth the evidence, and not only does it do that to explain why they made charging decisions, but in decisions, you also have where there is a lack of evidence, as we just talked about, that is the reason they didn't charge, for example, the inciting the insurrection. Now, by comparison, that's something that Hunter Biden's special counsel, David Weiss, really did not do, as we've discussed. One might wonder why he didn't do that. Maybe it would have run the risk of debunking another extreme Republican accusation against President Biden that's unfounded. Maybe that would have deprived the Trump regime of a go-to accusation they like to use. By comparison, though, Smith is not afraid of the truth. He sets forth in his report he did not charge the inciting an insurrection, and he sets forth why. Now, we can disagree with his exercise of prosecutorial discretion, but he puts it out there in sunlight for everyone to see. To Elie's credit, Elie Honig's credit, he does mention that later David Weiss's report also came out, but I'm really not seeing what kind of comparison there is. Elie thinks they're both kind of like too defensive and dramatic, but as I've discussed before, Weiss spends really the entire focus of his report defending himself and being pissed off at President Biden for pardoning Hunter Biden. But Weiss's report is not about the pardon of Hunter Biden. It's about the case and the investigation of Hunter Biden. It's quite different. Smith is laying out all the things Trump did and said, what they did. And Smith's report, unlike Weiss's, is not a food fight with someone. It's a report. And let's compare the cases. Smith had not one, but two sprawling cases against a former president that he wrapped up in about 2 years. Weiss had 2 charges against a non-office holder for tax evasion and false statements about drug addiction that took him about a half-decade to wrap up. So you compare. But I digress. Here's the third takeaway. The third takeaway is that Smith lays out what I think is the real culprit, besides the late start given to him by the DOJ. And that's the Supreme Court. And in the historical document that is now record, I'm going to put this part up because I found it to be a very important excerpt. He reminds us of the following, quote, "Before this case, no court had ever found that presidents are immune from criminal responsibility for their official acts, and no text in the Constitution explicitly confers such criminal immunity on the president. As set forth below, prior criminal investigations by the Department of Justice, whether conducted through special prosecutors, independent counsels, or special counsels, had examined whether presidents had violated federal criminal law through use of their official powers. None of those investigations had regarded former presidents as immune from criminal liability for their official acts. The office proceeded from that same premise." Now, one of those ex-presidents would have been President Nixon. This is easily forgotten in all of the detailed discussion over the years of Trump's various meritless legal arguments and the judges and justices who have enabled them. And now, with Trump back in office and the very lawyers who made those arguments on his behalf set to take leadership positions at DOJ, from the top down to number 2, down to the Solicitor General, it's easy, it will be easy to forget and distort these arguments into ones that had merit. But Smith is putting into the record that this was not the reality of the law before Trump, and that all this enabling came later and is too easily forgotten just how much distortion that happened. The Mar-a-Lago report, if it comes out, will be really valuable, but the chances of that are tough with the window of time rapidly closing. Another reminder of what the Supreme Court ultra-right majority has enabled. Late last night, early this morning, after reading the report, I had a kind of fresh reminder of what had changed. And we'll put up a screenshot of my kind of timely take on it then, my impression of it. It reminds us of what has been lost, right? Putting this out there makes us think about the things that got lost. The respect for the rule of law, treating the powerful equally, all those aspirational goals really have been lost. And you can't bring back what has been lost, but it's important to remember what they were and to remember how they were lost, so we have a chance at not having further losses and not making those same mistakes again. So I'll leave you with that thought. Great to talk to you. Thanks again for all the comments and the replies. Please keep them coming. Try to read them, and they're very helpful in terms of giving us ideas, not only about content, but sometimes about the set too. Thanks.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.